All right. And we'll now hear the case of K.D.M. and E.N.M. versus J.H.
I'd like to reserve 5 minutes.
All right.
May I please the court? My name is Patricia Strobridge, and I am here representing the appellants in this case, K.D.M. and E.N.M. This is an adoption case, and ironically, Your Honors, today is the 7-year anniversary of the date of the finalization of Aiden's adoption in Orange County. And we are rapidly approaching the 2-year anniversary of this court's decision to set aside that judgment and remand the case to determine if Mr. Hayden had done the things necessary under Florida Statute 63.062 to require his consent for that adoption. And if he had done those things, if his subsequent acts constituted an abandonment under 63.089 in order to waive the requirement of that consent. The trial court also was directed to resolve the issue of the statute of repose.
Well, and I know you start your brief talking about that, and I understand that there's a footnote in the earlier case that talks obliquely about that. The earlier decision of this court ends with these words: "We vacate the final judgment granting the adoption and terminating the parental rights of J.H. and remand for further proceedings." At that point, there is no final judgment of adoption and there is no order terminating parental rights, correct?
Correct.
Okay. Then you go to the statute of repose 63182, and what it says is that you have 1 year to attack a final judgment or any other statute, an action or proceeding of any kind to vacate, set aside, or otherwise nullify a judgment of adoption or an underlying judgment terminating parental rights.
Correct.
Okay. You have no final judgment at that point. There is no statute of repose issue because the final judgment's been set aside and the order that terminated parental rights had been set aside, and the statute of repose only addresses the time frame from which you have to attack a judgment or an order terminating parental rights. Am I missing something?
Yes.
Okay.
What you're missing is that the statute of repose is a subject matter jurisdiction issue. Without resolving the statute of repose, the court had no jurisdiction to even be hearing the belated appeal.
Wait a minute. What you're suggesting is that we had no jurisdiction in that first case.
Correct.
Well, a little late. It's a little late for that.
Subject matter jurisdiction can be raised at any time. It's been raised at every stage of the pleadings, and in fact, when we were before the Florida Supreme Court on the writ of prohibition, which they declined to decide on the merits but sent back on procedural grounds, the justices up there questioned the same issue. Why were we not deciding subject matter jurisdiction before we were deciding the case? But that is in fact what happened. Judge Mihawk made a very specific determination that there was no timely filing in this case. Then he went on in an April 2006 order on a motion to dismiss to say, well, despite the fact that he didn't file anything timely, which by definition meant he had no jurisdiction to go any further, he opined that Mr. Hayden could file for a belated appeal. And I'll submit to you that there's no such thing as a belated appeal in a civil proceeding. The Florida Supreme Court...
So we're here today to review what Judge Sawaya did back in 2009, is that?
Well, Justice Kennedy's statement was the procedural posture of this case makes my head spin. I can't fix the fact that it has become an onion where no one to date has made a clear determination of subject matter jurisdiction, but we keep on making decisions in this case. So the case has continued to go forward for now 6 years.
But you raised the subject. You were the lawyer on the earlier case, correct?
I've raised it at every time,
Okay,
and it can be raised at
You
any
raised
time.
it on appeal before the panel, which was Judge Palmer was on it, Judge Sawaya and Judge Orfinger. It was raised before that panel, correct?
Correct. And in a footnote, their statement was that the statute of repose will have to be resolved by the trial court on remand. And so at each stage...
Given the procedural posture that they set aside the very judgment and the order terminating parental rights, that footnote is a little confusing.
I agree that it is, and my position would be that if the court had no subject matter jurisdiction at that point, their setting aside that judgment was inappropriate. And I've made that argument all along.
You've made the argument, and it clearly didn't succeed.
It wasn't ruled upon. They just simply said the statute of repose will have to be addressed by the trial court and send it
The fact
back.
that they wrote an opinion in and of itself indicates that the court felt it had subject matter jurisdiction to hear the case.
It doesn't say that in any place in the decision.
Mr. Strobridge, let me see if I understand. What happened to the statute of repose issue after the opinion of this court, whatever it was, 2 years ago? Was that re-raised at the trial level?
It was raised at the trial level, and Judge Thorpe at the trial court level then, which was about the fourth trial court judge on the case, came back and revisited a pleading that had been filed prior to the expiration of the statute of repose.
Did she rule on the
She did rule on that pleading.
What did she rule?
She ruled that that pleading was a timely challenge, except that that exact same ruling had been addressed by Judge Mihawk not once but twice, and by the prior panel of the 5th DCA. The timeline had already been established. So the ruling from Judge Mihawk
I'm getting real confused now. If we sent it back and said, trial court, rule on the statute of repose issue, because apparently we were not satisfied. I was not on that panel, so I don't really know. We were apparently not satisfied with the status of the statute of repose issue at that time. If we sent it back to Judge Thorpe and said, rule on it, and Judge Thorpe ruled on it, then all we have to do is review it here now.
Except the 5th DCA gave her the timeline, and she changed the timeline. The 5th DCA, in that opinion from 2009, said the biological father filed on August 31st of 2006. That is more than 1 year after the statute of repose ran, or more than 1 year after the judgment was entered, and a year and a half after the statute of repose ran. This court didn't say determine if there was a violation of the statute of repose. It said resolve the issue of the statute of repose. So clearly there was a
Not sure
problem.
I understand the difference.
Well, Judge Mihawk considered the very same pleading that Judge Thorpe said was a good pleading. Judge Mihawk said is absolutely not a good pleading.
Judge Mihawk's ruling has been the subject of at least 2 appeals from this. And I think this is
and it is law of the case.
Yeah. And if we have sent it back and said, Judge Thorpe, rule on this, then obviously this court has not been satisfied with whatever the decision on the statute of repose was. So I think we probably ought to concentrate on the more recent determination, what the trial judge did that led to this appeal.
Well, and I would also point out to the court that the proceeding that was before this court called a belated appeal simply doesn't exist. There's no such thing as a belated appeal except in circumstances where a party has an entitlement to court-appointed counsel, and that court-appointed counsel fails to timely file a notice of appeal. That is the one and only time that that's recognized, and the Florida Supreme Court case of Sims v. State of Florida from 2008 goes through a lengthy explanation.
That was the 2009 proceeding, and I assume that you raised that at that point in time.
You cannot raise it. It had to go back to remand. It will ultimately have to be raised at the Supreme Court, I assume. But it was raised. The argument was raised.
Did you raise it in 2009?
The statute of repose was raised, yes.
Did you raise the belated appeal issue?
Yes. Okay. And so at this, but again, subject matter.
Now you want to raise it again in this appeal.
Because subject matter jurisdiction can be raised at any time.
The belated appeal issue isn't subject matter jurisdiction.
Well, that argument was PCA'd, so we didn't have an opinion that we could work on.
So
from that.
you get to argue it again.
So at this juncture...
Is that your position? You get to argue it again?
My position is that there are numerous reasons why there's been no subject matter jurisdiction since there was a determination by Judge Mihawk in 2006 and again in 2007 that there was no timely filing. That was clearly laid out. The timeline was laid out. The timeline was accepted by the 50CA in the 2009 ruling. And for Judge Thorpe now to go back and say, well, Judge Mihawk was wrong and the timeline was actually something different, and that solves the problem of the statute of repose, is really sort of a decision directed towards a specific end rather than looking at the law and applying the law. So at this juncture, I think we have to look at the subject matter jurisdiction. Someone has to take a close look at this and see whether or not any of these courts had subject matter jurisdiction to be doing what they're doing, because the case has proceeded forward without a determination of that. And so each court,
Sure,
Judge Mihawk
like
and
Thorpe,
the Fifth.
Sure, sounds like Judge Thorpe determined it to me.
Well, Judge Thorpe made a separate factual ruling that was contrary to the law of the case, because Judge Mihawk's ruling on the time frame was already appealed and decided.
She ruled on it. You're saying there was never been a ruling on it. She ruled on it.
She didn't have jurisdiction to rule. That's the whole problem. Once Judge Mihawk ruled that the time frame that had expired, there was no jurisdiction for anyone to rule on that. And the case
And you argued that to the last panel of the Fifth, and we wrote an opinion which addressed the merits, correct?
So we actually have a new case that I've submitted as supplemental authority in Re LMD.
You raised this issue in the last appeal, correct?
Yes. I've raised the statute of
And
repose.
this court addressed the case on the merits. We did not dismiss it for lack of subject matter jurisdiction, correct?
Correct.
Why is that not law of the case?
Okay. There wasn't a specific ruling on whether or not there was subject matter jurisdiction. There was.
Isn't addressing the merits of the case as opposed to dismissing for lack of subject matter jurisdiction a ruling that your argument that this court did not have subject matter jurisdiction was rejected?
I would say that if there's no ruling on the issue of subject matter jurisdiction and that ruling sends the very issue back to the trial court, that it's specifically saying we're not going to rule on this issue of subject matter jurisdiction.
But we addressed the merits of the appeal. We couldn't do that if we didn't have subject matter jurisdiction.
That's the question. There has to be a subject matter determination first and then ruling on the merits.
And therefore, ruling on the merits by implication means we must have decided the subject matter jurisdiction argument against you, correct?
I don't know that, because the issue of the subject matter jurisdiction was referred back to the trial court. And so it's not that it wasn't mentioned at all. It was mentioned. It was mentioned, and it was remanded to the trial court to decide as part of that same decision. That's what creates the complexity in the procedural history.
It's in a footnote, and, again, I keep going back to the fact that once that earlier panel set aside the final judgment and set aside the order terminating parental rights, there is no statute of repose issue, because the statute of repose simply is meant to have a timeline that if there is a final judgment, it's got to be attacked within 1 year. Well, after that opinion, there was no final judgment.
But if the court didn't have jurisdiction to even be hearing the challenge, that's the point. Well, I hear what the court is saying. I still think there's a subject matter jurisdiction issue, but I also want to move on to discuss the factual findings in Judge Thorpe's ruling, because the facts aren't really disputed. Mr. Hayden did not provide any support for this child from the time he found out about the pregnancy until May of 2009, when the child was rapidly approaching his 5th birthday. That would be a couple of months after this court ruled that if he didn't provide the support, his rights could have been terminated. So for a period of almost 5 or over 5 years from the time that he found out about the pregnancy until he realized that he might lose on the merits in the remand, he didn't provide any financial support. There was also evidence that there was emotional and physical abuse in this relationship, and the ruling...
Was that denied?
The emotional and physical
Yes.
abuse? Yes, it was.
Aren't we supposed to look at all the facts in the light most favorable to the party that prevailed below?
Well, It's
Yes
not-
or no? Is that
yes.
what we're supposed to look at?
Yes.
Then why are you arguing facts other than the facts in the light most favorable to the party that prevailed below?
Either way, it is undisputed that he took her to an abortion clinic and paid for a sonogram for her to have an abortion, and that is the only bill that he paid until this child was nearly 5 years old. She refused to proceed forward with
Was
the
there
abortion.
evidence he offered to pay and the offers were declined?
Well, the judge said that he offered to pay, except he testified that he never spoke to the birth mother after April of 2004.
Did you speak to the grandmother?
He said he spoke to the grandmother on 2 occasions in September of 2004 and never spoke to her again after that. So there was no tender of support. When he finally did begin tendering support, he didn't tender it directly to them. He tendered it through his attorney to my office. So it wasn't necessary for him to actually have telephone communication, but the court found that he was excused from providing support because the birth mother refused to speak to him on the telephone. And so there's a reference in her decision about the fact that he didn't know for fact that he was the father of the child, but none of that is the standard for providing support. The legislature intended for unmarried biological fathers to step forward and show their intention to assume parental responsibility. The fact that other people paid for her support, or the fact that Medicaid covered her bills, or the fact that she wouldn't talk to him on the phone does not excuse him from providing financial and emotional support to her and the child. And there were no cards, there were no letters, there were no gifts, there were no diapers, there was no money of any type for this child until years later. And the case of JCJ versus Heart of Adoptions is directly on point, and JCJ's parental rights, JCJ doing more than what Mr. Hayden did, his rights were terminated for abandonment. So I would remind the court that there are two standards. One is whether or not he had abandoned before the consent, which would determine whether or not his consent is required. And then if he had not abandoned before the birth, did he abandon after the birth, such that his requirement of his consent could be waived? And we would submit that it should be.
Counsel, is there any question that he is the father? I actually,
Not at this point. There was earlier in the case.
Everybody agrees.
But there has been DNA testing at this point. There were 2 possible men at that time.
Okay, thank you.
Good afternoon, Your Honor. My name is Edward Jordan. I have the pleasure of representing Mr. Hayden. As the court notes, this has been going on now for 7 years. May I address the issue, the latter issue first, which seems to be some sort of argument about abandonment, which I think is under 630894, which has never been pled in this case. The court will note that the petition for adoption was filed, I believe, 6 days after or 5 days after the child was born.
Well, but it's been tried, hasn't it? Hasn't the issue of abandonment been tried by these parties in some detail?
I think it's been tried under 60...
Well, then
yes,
the fact that it might not have been pled, if it's been tried, then you try it by consent.
Yes, but we tried it under 630893. And there's a different standard between 0893 and 0894. And that's the key element, I think, that the court needs to make sure it addresses, because under 0894, this emotional issues that were factually not supported by the argument here today does not fall under 69083, because 0893 requires proper service. And you don't have abandonment until you've been served with a pleading. The evidence, the court record is that we were not served with any pleading until about a week or 2 before the ultimate trial, at which time then you have to file your affidavit of support, affidavit of ability and what you plan on doing. Mr. Hayden timely filed his affidavit of responsibility in accordance with the statute days after he was served with the petition. So the difference between 0893 and 0894 is that the abandonment, we believe, and I think accurately reflects, was tried under 0893. And I also say that the facts of this case establish and support Judge Thorpe's finding that there was that Mr. Hayden's efforts were thwarted by a web of lies, misdirection, and a conspiracy by the entire family, including not only the adoptive parents, not only the birth mother, but also the siblings and son-in-law. All of this, working together in secret, resulted in the mother filing her consent for adoption the day she was released from the hospital. And that's important because the statute upon which the conditions precedent for whether or not Mr. Hayden was entitled to notice, under 63062, it applies only to the time between the birth and the time that the birth mother files or signs her consent affidavit. Judge Thorpe rightfully found that Mr. Hayden did have knowledge of a pregnancy up until August 8th, 2004. After that point in time, Mr. Hayden was led to believe and was told that the unborn child had been aborted. Leave us alone. Stop harassing us. This was after multiple phone calls. The court also found that when Mr. Hayden was testifying that he actually met with the son-in-law about a wedding that was occurring in July and why he wasn't invited to the wedding, seeing that he was a friend of Mr. Hubbard who was getting married. And Mr. Hubbard said, obviously you're not going to be invited because of the past abortions, plural. Mr. Hayden even had his mother testify that she called the adoptive parents and was told the abortion has occurred, stop harassing us, we're getting ready for a wedding. All said and done, Judge Thorpe's finding that he had no knowledge of the pregnancy after August 8th until the time that he received a phone call from the adoptive mother, Mrs. Montalvo, means that the court, Mr. Hayden did not have an opportunity or have knowledge of the pregnancy from August 8th until the date the child was born or the consent affidavit was filed. Therefore, we believe that all of the evidence supports Judge Thorpe's findings, which come to this court with the presumption of correctness and the presumption being to Mr. Hayden that it is correct in the light most favorable to Mr. Hayden being the prevailing party. Having said that, Your Honor, the statute of repose does not apply, regardless of, and we have argued the position, Judge Cohen, with regards to the fact that once the judgment has been vacated, there's nothing, the statute of repose is not implicated. But more importantly, Mr. Hayden timely filed an action of any kind to annul the adoption or the termination of termination of parental rights within the 1 year, specifically in November of 2005, within the year anniversary of the final judgment that was subsequently vacated. So having said that, the statute of repose, even if it would apply, was met because of the filing of the amended petition, which was an independent action. The adopted parents' argument here today that there was some sort of timeline or the footnote by Judge Mihawk that the motion to dismiss filed in 2006 was not an independent action somehow finds that the amended petition wasn't timely filed is inaccurate because Judge Mihawk's habeas corpus ruling was per curiam affirmed, statute of repose was addressed, the writ of prohibition was argued in front of the Supreme Court. Again, these very same arguments have been denied 3 times. We're asking the court to deny this appeal and let this matter continue in the paternity action as is now pending. If you have any other questions, otherwise I'll sit down.
Thank you, counsel.
Thank you, Your Honors.
Ms. Strobridge, you have about 3.5 minutes.
Thank you. On the issue of the support, if this court finds that Mr. Hayden was excused from providing any financial support for her because of whatever he said, she said was going on between them when the statute establishes an objective standard, if the fact that he did not know unequivocally that he was the father of the child because there was another potential father excuses that financial support, then the requirement of financial support means nothing. If that man is not required to provide financial support and to invest in that child prior to the child's 5th birthday, then it is meaningless. And so Judge Thorpe excusing him from doing nothing, not a request for a picture, not a phone call asking how the child was doing, all he did was litigate. And so I've cited in my brief multiple cases in which the courts have said, that's not it. That's not what you need to do. What the legislature wants you to do is step forward and show your willingness to assume responsibility for the child. That didn't happen, and at this point in time, it's not something that can be corrected. Nobody provided support for this birth mother during her pregnancy.
Where's the child at now?
The child lives in the grandmother's home, and the birth mother is required to live there as well because Judge Thorpe changed custody to the birth mother. So in order to prevent harm to the child, the birth mother moved into the grandparents' home to assist in the transition. The child visits with the father. So at this point, my position is that if Judge Gridley, back in 2004, if Mr. Hayden had been provided with notice, which he wasn't provided with because he didn't update his address, and there's a big dispute about whether or not the grandparents knew what the mother knew about where he was located. But let's say they did, and they'd served him with papers. Judge Gridley's decision would have had to have been, did he provide financial support for her during the pregnancy in accordance with his ability to pay? The unrefuted facts are that he was employed full-time and that he gave her nothing. And so she was indigent, and he knew that. She was living off the charity of her parents and friends. She testified that she used her savings to pay for some of her expenses, and her parents paid the rest of them. Medicaid covered the medical bills. She asked him if he would pay for her to go and see a doctor, and he declined, saying she would see a doctor at the abortion clinic. And so the reference, by the way, Mr. Jordan's reference to the multiple abortions is that because this wasn't the first abortion he had taken her for. He called, he made the appointment, he took her to the clinic. And that had occurred on 2 other occasions. And at this juncture, she is a destitute mother trying to make the best decision for her child, and that would have been what Judge Gridley would have been faced with. That would have been 63.062, 2B. If you project it forward, 63.089 comes after that. Has his actions after the birth of the child constituted an abandonment of the birth mother? And from that point, I would suggest that since he knew unequivocally about the birth of the child within a matter of a couple of weeks after the child was born, and he took no steps whatsoever to establish any kind of a relationship, never even asked the court to establish a relationship, that is an abandonment, and his rights should not be protected. And if this court supports that decision from Judge Thorpe, then it essentially wipes out the requirement for financial support.
Okay, counsel, your time has expired.